Hello, thanks a lot for watching this video. The purpose of this video is to explain to you the elements of your case. It's very important that you understand the elements of your case. It's important that you understand these elements because they have a huge impact on the value of your case. So what we're going to do is talk about the elements in detail, and I'm going to go through each of the elements, explain them to you. And what I've done here is draw on each element like a hurdle in a race. It's a good visual. I've used this a lot in mediations. Sometimes I use it at trial to explain things to a jury. But just like the hurdles in a race, we have to overcome and get over every single hurdle before we get to the next, before we get to the finish line, which in your case is a resolution that you're happy with, a settlement or a trial verdict that you're happy with. The first element is what we call the liability hurdle. This is where we start the evaluation of your case. This hurdle concerns whether or not someone did something wrong, they were negligent. In an automobile accident case, that liability can be very easy to establish. If you were hit from behind, it's very easy to establish and to argue that the other person, the person that hit you, is at fault for the accident. However, if you were involved in a premises liability case, a trip and fall case, a slip and fall type case, this hurdle is more difficult for us to overcome because we have to prove that the property owner knew about a dangerous condition on the property, didn't do anything about it, or didn't warn you. This is the very first element in your case we have to prove. And as I said earlier, if we don't prove that the other person was at fault, you do not get to these other hurdles. We do not get to the finish line. Focusing a little bit more on liability. You're going to hear potentially in your case something called comparative negligence. This is a concept in the law where even if the other party is at fault, that party can argue that you too were at fault. That's expressed on the verdict form as a percentage. And having tried cases, I can tell you that the very first question on the jury verdict form is whether the defendant was negligent. If they mark yes, then they get to the next question, and that question is, were you negligent? If they answered no to that question, then the defendant is 100% responsible for your damages. If, however, they answer yes, that you were comparatively negligent, then they get to express your negligence and the defendant's negligence as a percentage. Two percentages, they must total 100%. Those percentages can be anything between 1%, 99%. In an automobile accident case, we typically see comparative negligence issues when our clients are not wearing their seatbelt, or maybe our clients were at fault to some extent. Maybe they received a citation. Those issues are very important for you to understand as we're talking about this very first hurdle, the liability hurdle. And again, it doesn't matter how serious your damages are. You could have a catastrophic injury. There can be a death involved. If we can't prove liability, then we don't reach the finish line. There is no resolution. Having done this for over 25 years now, I know that my clients typically focus on the damages hurdle. That's because this is what you suffer on a day-to-day basis. This is where your lost wages are. This is where your pain and suffering damages are. So naturally you're not a trained lawyer, you're focusing on this hurdle. But what you can see here is that the damages are the last hurdle we get to. We got to get over two other hurdles before we even get there. So once we overcome the liability hurdle, we get to the causation hurdle. Now, causation and damages are related a little bit, but they are different. They're different elements in your case. Causation means that we have to prove that the negligence, the fault, the bad conduct, the wrongful conduct on behalf of the other party actually caused your injuries. Let's take an automobile accident case because that's the most common case that we handle. So let's assume that you're hit from behind. Clear liability. We can easily establish that the other party is at fault. and let's say you have a herniated disc in your neck, and that shows up on an MRI. We argue that that herniated disc was caused by the negligence of the other party. But the defense in this case, the other party in this case, will fight that. What they're going to argue is that that herniated disc was caused by something other than their negligence. They may say, we're sorry, we caused the accident, we hit you from behind, and it's our fault. But we didn't cause your herniated disc because 5 years ago you were involved in another crash. That's the crash that caused your herniated disc. Or 2 years before our accident, you fell on the sidewalk. That's what caused your herniated disc. And remember, the defense in this case will argue typically every single element. We have to win all of these to get to the finish line and get a settlement or a verdict that you want. The defense only has to win on one of these. So you can see that we have the higher burden. We have the higher hurdles, so to speak, to overcome in order to win your case. The causation hurdle can get very complex depending on your medical history. We get lots and lots of medical records. Monica, who you'll be working with early in your case, will be gathering all of those records. And what we do is review those records to see how strong we are on this causation element. And oftentimes what we find is, again, using our herniated disc case as an example, is that we have a current diagnosis of a herniated disc, and the doctor does in fact say that it's related to the negligence of the other party. But because we all have life experience, we've gone through a lot of things, we find other things in the record which the defense can potentially argue was the cause of your injury. This is why when you're given instructions from my office about giving accurate histories to all of your doctors is very, very important. Very, very important. Because if you're not giving an accurate medical history to your doctor, for example, if your doctor asks you, have you ever been involved in a car accident before? Have you ever had neck pain before? And if you mistakenly say no, and the doctor relies on that to formulate or come up with his causation opinion that your herniated disc in our example was caused by the liability, that doctor's testimony now is subject to attack because the doctor didn't have all the information. If you tell the doctor about your prior medical history and you're completely accurate about it, what the doctor can then say is, well, sure, Mr. Cavonis' client may have had some pre-existing conditions, but they weren't as bad as they are now. They weren't as severe as they are now. Because we don't have to prove here in this causation area that the negligence caused your injury 100%. All we have to prove is that the negligence made either a pre-existing condition worse or caused some type of new injury. And for example, in a low impact case, when I say a low impact case, I'm talking about an automobile accident case where there's not a lot of property damage. I like to see some pre-existing problems. Maybe they're degenerative changes. Maybe it's a bulge or something. Because then our argument, our theory of the case is that you're more susceptible to an injury from even a modest impact. And it's kind of counterintuitive for a lot of people. A lot of people want to hold back that negative history from the doctors because they think it's going to hurt their case, when in fact it actually helps your case. So if you have a herniated disc from our crash, and 3 years prior to that, you had neck problems, but it wasn't herniated. Maybe it was just a bulge, or even if it was a herniation, maybe it wasn't as bad as it is now. That's good information for me to help win your case. So the point here is that you want to make sure that you're being completely accurate with your doctors about your medical history. Monica likes to tell our clients to bring a complete list of their prior medical history so they can read it to the doctor. Because what will happen in your case is that you're going to see multiple doctors, and you want to make sure that you're being consistent with what you're telling every single doctor. Let's talk about this third hurdle now, this damages hurdle. We talked about this one earlier, and I told you that most clients naturally focus on this hurdle because this is where you're suffering. This is your pain and suffering, your lost wages, your out-of-pocket expenses. So we overcome these hurdles here. We get over liability, we get over causation, and now we're focusing on the damages in your case. The damages in your case depend heavily on the nature and extent of your injuries and how those injuries have affected you. One of the most obvious examples that I give, oftentimes I'll give this example in court, is maybe the amputation of a pinky. If I lose my pinky, my brain still works. Some people would argue to varying degrees, but my brain still works, my mouth still works. It doesn't really affect my life. It doesn't affect my job. It doesn't affect my day-to-day activities. But if I was a concert pianist, I played the piano for a living. It's a catastrophic, life-changing injury. It's the same injury, but it affects people differently. And our job as your advocates is to make sure that we're properly conveying to the people who ultimately will decide your case, whether we're trying to convince an insurance adjuster to pay more money than they want to pay, or trying to convince a jury to give you a large award. It's our responsibility, it's our job to make your damages stand out, to show how these damages have affected you in a very unique and personal way. Monica will tell you to maintain a diary, maintain a list of how your injuries have affected your life, and that's very, very important for you to do, because over the course of your case, when we get to the end and we're starting to put everything together and do a demand, or we're preparing for trial, you're going to generally remember that you hurt, you were upset, maybe you lost some work, maybe you couldn't go on some vacations. But what you're not going to remember are all of the details that make your case really stand out. This is why the diary is very important, because what you'll be able to do is tell us that on a particular day, maybe you got so depressed that you cried because you couldn't lift up your grandchild, or you felt really bad because you couldn't go with your spouse to an important family event. It's that type of detail that really helps us prove your damages. So make sure you are keeping that diary, because we're going to ask you for it when we get ready to do the demand. And it will really help us convince the insurance company, convince a jury that you have real damages as a result of the negligence of the other party in this case. Now, this is a good time for us to talk about the different categories of damages. There are what we call non-economic damages and economic damages. Non-economic damages are the damages that we can't really calculate with a lot of certainty. There's no formula, there's no book, there's no reference material for us to look at. Those include mental pain and suffering, loss of the capacity to enjoy life, depression, anxiety, all of those types of things. Those are very real damages. We see those in many of our cases, but as you can imagine, they are difficult to quantify. And I've been doing this a lot of years, over 24 years. The law doesn't even really provide a whole lot of guidance as to how you calculate those damages. But you keeping that diary and giving us all of those details will help us convey to the other side how you have personally suffered. So those are the non-economic damages. The other category, what we call economic damages, those are fairly easy to calculate. Those are things like your lost wages. Now, lost wages come in two varieties. We have past lost wages, and then what we have is called loss of earning capacity. Past lost wages, as the name implies, are those wages that you lost in the past. Those, of course, are a lot easier to calculate because it's historical data. I mean, we know that you had a job, you missed work, and then we can simply, add the days that you missed, multiply it by your wages, and come up with an amount. The loss of earning capacity portion of that is a little bit more difficult because it's prospective or in the future. So imagine we are sitting at a mediation, which is nothing more than a settlement conference. I have another video that talks all about mediation, so don't worry about that now. But imagine we're sitting at a mediation and we're talking to the other side about your lost earning capacity, your inability to work in the future. The types of things that the defense is going to argue is that, well, maybe you didn't intend to keep that job. Maybe you intended to quit that job anyway, or maybe you were going to take an early retirement, or maybe you were terminated for a reason totally unrelated to the negligence of the other party. This is where your personnel records with your employer really come into play. If you're missing work as a result of your injuries in our case, it is very, very important for you to specifically tell your employer why you're not coming in. Because at some point, all of your employment records are subject to discovery, and that simply means that the other side can get them. And looking at it from their standpoint, it's obvious what evidence would be more persuasive. If your employment records simply say that, well, the person called in sick today, that doesn't really help us with any of these elements. If your employment records specifically say, our employee was involved in an automobile accident and called in and said that they couldn't work because they have a lifting restriction or their neck hurts, that helps us with your damages. It helps prove the damages. So it's very important that you tell your employer, if you're missing work as a result of our case, exactly why you are missing the work. And you can even talk to someone in your HR department, if you have an HR department, to make sure they document it that way. They're used to those types of requests, so there's nothing unusual about it. And maybe a simple statement that, to them, that you simply want to make sure that the reason for your absence is well documented, because that helps us a lot with this damages hurdle. Also in this category of damages are your out-of-pocket expenses. You're going to be given a sheet to log in all your out-of-pocket expenses, and what we typically tell our clients is to put everything on that sheet. Don't editorialize, don't withhold something because you think you may not be able to get paid for it. Write it down, save your receipts, tell us why you got it. I mean, anything from, a special pillow, a mattress. We've had people write down hot tubs, and, doctors have in the past actually written prescriptions for therapeutic hot tubs. So I don't want to prejudge it. What I do want to do is make sure we're capturing all of that information. So when we need it to make a demand in your case, it is available. And at that point, we'll discuss what you are and are not entitled to get reimbursement for. Monica gave me a list of things that she wanted me to mention on this video. One of the things that is important for you to understand is that the receipts are very, very important, actually getting the proof of these various expenses. One receipt that we do not need, and we get these receipts all the time, are gas receipts. We do not need those gas receipts. You're going to use the mileage form to log in your mileage, and that mileage form is used to get you reimbursed for your or from your no-fault benefits. Other receipts that we do want, documentation that we do want, relate to replacement services. You mow your own grass, you injure your back, you can't mow your grass anymore, and you have to pay someone to mow your grass. Get receipts. Make sure that you are paying for all of these expenses via check or by some other method which will generate some paperwork that we can use. Cash, as you can imagine, isn't particularly helpful because defense attorneys are always very suspect and suspicious when we argue to them that there's been a lot of payments in cash. Hair and nail salon receipts, that's also very important. We represent a lot of women who have upper extremity injuries, neck injuries, and it's very difficult for them to do their own hair, do their own nails. Those are real damages. So if you have that damage in your case, make sure you give us those receipts. Medical devices are something else that we want to make sure that we get documentation about. For example, you may have been prescribed a brace, a heating pad, ice pack, TENS unit, which is a stimulator. Make sure that if you are filling those prescriptions, and you should be filling those prescriptions so you are following your doctor's recommendations, make sure you give us all of those receipts as well. Now that we've talked about all of these hurdles, I again want to stress the importance that you understand that me, as your lawyer, I need to overcome every single one of these hurdles. We'll kind of put this arrow here to overcome the final damages hurdle before I can get you to a result. So as you are focusing on this hurdle, the damages, when you're telling us about how hurt you are and how your injuries have affected your life, understand that we also have to focus on causation, we have to focus on liability. Because no matter how badly you're injured, no matter how severe your damages are, if we don't prove liability, or if we prove liability but can't prove causation, we can't get you to the result that you want in your case.